me think about it. Okay. Let's go back on the record. You can all be seated. We're back on the record in the Winslow case. The record reflects the presence of all counsel. Mr. Winslow is present. The jury has been discharged. I know that the attorneys spent quite a time speaking with him. The one thing I neglected to do after I declared the mistrial was ask about the splits for the counts. We did inquire of the jury back there in front of all counsel. The splits were as follows for the record. Counts 1 through 3 was 7-5 for guilty. So there were 7 guilty votes. Count 5 was 10-2 for guilty. Count 7 was 10-2 for guilty. Count 8 was 8-4 for guilty. And counts 11 and 12 were 10-2 for guilty. So that was the official split for the verdicts on all the remaining counts. We're going to go ahead and meet for a status conference this Friday. It'll be at 10 o'clock in the morning. I think we'll go ahead and do it in Department 12. And at that point, we'll discuss setting new dates or possible new motions. The due course trial date right now is July 29th. Is counsel available on the 29th to try the case? No? All right. So, well, we need to set a new trial date. Does your client want to enter a time waiver right now?
Can we deal with that on Friday?
All right. Well, then are you still looking at the July date?
No.
We can set, the court is open for trial on July 29th, and then we can do it from that point forward. But why don't you talk to your client about a time waiver, but that's the date that we have set for his statutory right for the speedy trial. Are the people, would people be ready on that date?
We're available.
All right.
You want to do a time waiver now then?
You want to just do an open time waiver?
Yeah.
Okay. All right, why don't you talk to your client about that? Okay. All right, so Mr. Winslow, you do have the right to have your new trial set on July 29th, and we have 12 days remaining to get your trial out from that date. That means that your trial would have to start no later than August 12th. You do have the right to a speedy trial, and you don't have to wait time if you don't want to, but I think to work things out with your attorneys, it might be to your benefit to do that. I don't think you're going to go out and hire some new attorneys between now and then, but that's your choice. So do you understand that you do have the right to have your trial set on July 29th?
Yes, sir.
And do you give up that right to determine a trial date when we come back to court on Friday?
Yes, Your Honor.
All right, then the court will show an open time waiver, and we'll see everybody back here in court. We'll be in Department 12. That's going to be at 10 o'clock this Friday. So, Mr. Owens, you can talk to the powers that be in the DA's office and see what you want to do. And if there's going to be any motions that are filed, you can either file them on Friday or we can set a motion filing schedule. But I would ask that the council talk amongst each other and try and come up with a mutually agreeable trial date. And you can even just email the court and I'll let you know what my schedule is. But I'm pretty much open from the end of July to the end of the year. Okay? All right. Are there any further requests by the people? No, thank you very much. Any further requests by the defense? No. All right. We're in recess. We'll see everybody back in court on Friday at 10 o'clock. The defendant will continue to be held without bail. We're in recess. Thank you.